Hi, I'm Charlie Cradaville, and welcome back to the Jersey Machine.
Last time, we traced how New Brunswick's longtime police director, Anthony Caputo, built his power. He was double dipping. He collected a $376,000 boat check for his unused time off. He allegedly got in a physical scuffle with another officer because of his political activities on behalf of the future Mayor Jim Cahill, the man who would become mayor for the next 35 years. Caputo thought he could move 2 hours away and still remote control New Brunswick's police department in secret.
And when I uncovered that, city officials tried to use Daniel's Law to shut me down. New Jersey's version of Daniel's Law lets thousands of public officials demand takedowns of information from the internet, even when that information is true, public, and newsworthy. And that's where the danger comes in. So to fight back, I reached out to the ACLU of New Jersey and brought in Alexander Shalom, one of the state's top constitutional lawyers, who explains why the outcome could affect every journalist and every resident in the state. Stay with us as we follow the case step by step all the way towards New Jersey's Supreme Court. Alex, thanks for joining us today.
It's my pleasure to be here. Thanks for having me, Charlie.
This is an area where you are one of the top people. About how many times have you been before the New Jersey Supreme Court arguing?
More than 100.
Wow.
This will be my 104th or 105th argument, something like that.
Well, it's an honor to have you on the case. Why did ACLU take this on? Why did you think this was an important thing to challenge?
So there's this core First Amendment principle in a series of cases that we call the Daily Mail cases that basically say when a journalist lawfully obtains information on a matter of public concern related to something that the public is worried about, the government can only prevent its publication in the rarest of circumstances. And what they have to do is show that it's a need of the highest order. It's an incredibly important thing, and that their method of preventing that harm, of fixing that thing, is the most narrowly tailored possible. So it's the least onerous way of doing it. There aren't alternatives that would be equally effective that would cause less chill. And we didn't think they could do that in this case, and we think it's an important principle because, this is the same principle that animated the New York Times' ability to publish the Pentagon Papers, right? Government came to court and they said, listen, we are going to be harmed if they're allowed to publish the Pentagon Papers.
So the Pentagon Papers was a report that the U.S. government had commissioned to analyze the Vietnam conflict, and it had exposed that not only was the war unwinnable, but the government had been deliberately misleading its own citizens about it. So a man named Daniel Ellsberg stole it and gave it to the New York Times, and the Nixon administration went to court to try to stop the publication.
It went all the way to the U.S. Supreme Court, and they determined that the New York Times could continue to publish it because it was not actually endangering the troops. And so they set a very high bar for the government to prove in the future that something was so dangerous that it had to be stopped prior to publication. And it wasn't a unanimous verdict, but that's sort of been the standard ever since.
And that's an interesting case too, obviously, because Daniel Ellsberg broke the law, right? He stole the Pentagon Papers and gave them to the New York Times. There was no law breaking in your case, but the bigger point is the New York Times didn't break the law, and therefore they can't be punished for the fact that their source did. They didn't commission it. They didn't do anything like that. This principle has been important in getting the truth to the public. And we see every day how important it is to have journalists who are willing to get at and tell the truth. And any opportunity we give the government to limit journalists or limit those who want to criticize the government from getting the truth out there is harmful to democracy. And that's why the ACLU was interested in the case.
And Charlie, you've actually dealt with this before, with a situation where a source gave you stolen evidence to prove corruption.
Yes, I can remember back when New Brunswick police got a search warrant for the New Brunswick Today newsroom to come and take rusty old water meter that had been given to me by a confidential source, and it was proof of corruption. There were a couple of guys in the water utility who had a scam going where they were giving their friends or people who bribed them phony water meters that didn't ring up charges. Big investigation, and we actually did a live broadcast with the water meter on our New Brunswick Today show, and the police became interested in this. They contacted us. They viewed it as stolen property and that some crime had been committed, and they executed a search warrant on our office and took the water meter. And they wanted to take more. They wanted to take our recording of the show as well.
Just got a search warrant signed by the judge.
Okay.
So you had to come look for this water meter.
You have the water meter
I do.
supply to us? Okay.
I do. This is the water meter.
You don't have any other water meters that we should be looking for, do you?
There might be one attached to the building, but
Okay.
that's not mine.
As far as the SD card of the original video, or any medium with the original video that has the original broadcast you had on there.
Gentlemen, it's on YouTube. That is, that's all. I encourage you to check that meter out. There's got to be a reason that it's all zeros. It's a zero read. It looks like it's been used. I think there might be some funny business at the water department.
I never saw the water meter again. But yeah, back at that time, I became familiar with these principles of you can't punish the reporter for accepting ill-gotten information. And in this case, it was a rusty old water meter.
And we'll hear from Alex a little bit more on the precedents behind this.
You talk about this line of precedent, and what are some of those cases that have come up, and how do you think that should be in our favor?
So the Pentagon Papers case is one of them, and it's probably the best known. But there are a series of cases that deal with things like the identity of juvenile defendants. And so what happens typically in those cases is court holds a public hearing where they mention a defendant's name. And then, and the journalist witnesses this and now wants to report on it. There was a 14-year-old charged with murder or something like that. And the court says, no, if you do, you're breaking a law that keeps the names of juvenile defendants private. And the Supreme Court ultimately says in those cases, you could have kept it private. You didn't have to let the journalist into the courtroom. But once you did, you can't now punish their ability to write about it. That's one kind of category, and there have been a couple of those. And there have also been cases that have dealt with the names of victims of crimes. And the one I think that is most helpful in our case is called the Florida Star versus BJF. So Florida had a law that prohibited the naming of victims of sexual assaults. It's again, a laudable law designed to protect the privacy of victims. But there was a rape that happened in Florida, and in a police station that had like a press room, they left on the table in the press room a police report that had the victim, whose initials were BJF, had her full name. And a reporter wrote it down and published it as part of a story about this rape. Now, let's keep a couple things in mind. At the time the story was published, the perpetrator of that crime was still at large. So there were real serious safety implications for BJF with having her name published. But the court said, look, sure, it's important to talk about, protect the privacy of rape victims. We'll grant you that. But they had an easy way to do it, which is don't hand over the information in the first place. Once they leave it in the press room, we have to come to the conclusion that they had a better way to protect it, and they chose not to do it.
So at this point, both sides have submitted briefs to the court. You and Alex submitted a brief, and the city and Tony Caputo submitted their reply brief. And Tony Caputo starts revealing some new things about himself in that brief.
Yeah, we got to start to see their side of the story. I'll read from the reply brief here. Quote, to maintain the neutrality of the New Brunswick Police Department, Director Caputo does not participate in public events or town halls. Director Caputo similarly prohibits his officers from speaking publicly about politics. Director Caputo does not attend New Brunswick City Council meetings, nor is he required to attend. Of all people, Tony Caputo is trying to maintain political neutrality. I mean, he's one of the most political police I've ever come across, and certainly he has not been shy about supporting the mayor in his election campaigns throughout his career. So It's really an evasive guy who's trying to frame it as righteous, that he's not showing up in places where you might have accountability, where you might have somebody ask you a tough question, be they a city council member or a member of the public.
Right. There were other things we didn't even get into. Like, I think back in the 90s, he was providing a public service to assist the elderly with voting.
In 1992, there was a close election for city council, and Tony Caputo, of course, was backing the political machine, Mayor Cahill's candidates, and helping to get out the vote through absentee voting. So he was helping old folks cast their ballots, and one of them, because the election was so close, had to come in and testify on her own behalf in the case over challenging the results of that election, which I believe was only 9 votes apart. Both sides kind of try to get their people to show up and say, I voted, it was really me, and I want it to count. But this voter, when asked, couldn't even really remember who she voted for. She did remember that it was Tony Caputo who helped her complete the ballot. It's my understanding he had continued for a long time, specifically getting seniors, getting the elderly community to vote for his candidates.
So he's making the argument that the reason he doesn't come to council meetings is because he's not a political guy, but that wasn't the only new thing he revealed about himself.
Yeah, that's right. On page 8, they, for the first time, tried to explain that he has 2 residences. So they say here, quote, when serving New Brunswick, the director rents additional residences, first in New Brunswick and currently in East Brunswick. So that was the first I learned of that. I've never been able to verify it because they didn't provide any supporting information like a lease or anything like that. But we had been asking and trying to investigate his residency for a long time and getting all kinds of stonewalling and obstacles. And so I have no way of knowing whether or not he actually had a second residence closer to New Brunswick and how much time he actually spent there versus his nice home in Cape May.
Okay, so at this point, you're heading towards your first court date.
August 23rd, 2023 was our first day in court. And, we went in thinking we might be able to get this over with today. We were before Judge Alberto Rivas, and we got thrown a curveball pretty quickly. Tell us about that.
We actually had filed in July. And so we wanted to be heard in July. And the judge who signed our order to show cause, who essentially said, this is an emergency, we can do some stuff on a quick basis to decide what's what, assigned the case to Judge Rivas. And Judge Rivas, at some point, moved the date, adjourned the date, and he did that twice.
So after Judge Rivas delayed the court date multiple times, you finally made it into court on the 23rd. The scene was crazy and things got weird.
Yeah, it was a packed courtroom with lawyers for all the big police unions. I was there, Caputo was there, the city attorney was there, as was, of course, Alex Shalom.
But then, even though all those people had shown up to court that day, Judge Rivas actually tried to delay it even more by citing something called a 60-day deference to the Attorney General.
Yeah, so apparently whenever you challenge the constitutionality of state law, you have to put the Attorney General's office on notice. But of course, my counsel knew that and did that and followed it exactly. So there was really no good reason to delay any further because, again, we were seeking emergent relief for an ongoing violation of freedom of speech.
So once Judge Rivas realized he wasn't going to be able to delay the case any further, he actually disclosed one last thing.
So the other thing is, in full disclosure, I am friends with Judge Salas, particularly the amicus, started all their briefs with great detail of the tragedy involving Judge Salas. My relationship with Judge Salas goes back to when I was an assistant United States attorney and she was an assistant federal public defender. We had cases together. We have remained friends. We socialize. We hang out. We have seen each other. Question is, does anybody object to or has concern about that relationship?
And Alex Shalom found that revelation very surprising to come at that point.
I was taken aback because normally when a conflict comes up, as soon as the judge knows about it, they'll tell you. And in this case, we had filed briefs, we had filed a reply brief, he had gotten a lot of paper in the case, so there was no mystery, but that this case was about Daniel's Law and that Daniel's Law had a relationship to Judge Salas. And so you and I spoke and we ultimately told the judge that we weren't going to object to his presiding over the case despite the relationship. And this is frankly because we wanted to get moving with the case. There had been enough delay already. And I said at the time, but I'm frustrated to be learning this now. I'm surprised to be learning this now. And Judge Rivas said, because Judge, this is an emergency. My client's First Amendment rights are being impaired. And Judge Rivas said, but I don't think it's an emergency. And that was a very surprising answer to me, because that's a decision on the merits of the case. It's one that a judge is entitled to make. But once you've made that decision, you are participating in the case. You're making a legal determination in the case. And obviously, if you're encumbered by a conflict, as Judge Rivas feared he was, you shouldn't be making that sort of merits-based decision in the case. Ultimately, though, despite the fact that we didn't object, the city did.
So even though you weren't going to object to Judge Rivas on the case because you wanted to get things moving, the city did object, so he recused himself.
Yeah, so I mean, the court ended for our session, and we kind of regrouped in the hallway and decided that we weren't going to just, accept this as needing to come back another day in the future. So we walked straight to the assignment judge and spoke briefly with him. That's Michael Toto, who took over for Judge Rivas when he was demoted. And
Wait, he was demoted?
Yeah, so Judge Rivas was at a time the top judge in Middlesex County, but the Supreme Court ordered him to be demoted because of inappropriate remarks he made to a litigant. This litigant was a woman who basically was the victim of what we now call revenge porn, or, her ex was sharing nude photos of her without her consent with other people, and she wanted some kind of recourse, and the judge made a number of comments that were really not appropriate.
What did he say?
The one that was most widely reported was he said, basically like, Miss, the only man that you should send naked photos to is Hugh Hefner, because he'll pay $100 for him or whatever. He said something ridiculous for a judge to say, and it was he was also there was another person who was in the room that day who he was saying nasty things about, like I'm gunning for you. And so it was like really just a wacky,
yikes.
And he's the top judge. He's the boss of who's assigning which judge goes where in Middlesex County. So that was not allowed to continue after that complaint made its way into the Supreme Court. They said, you're demoted. You're just back to being a regular Superior Court judge. And so I've actually had a number of cases before Judge Rivas over the years.
Okay, but going back to that first court date, so first it was with Judge Rivas, then it went to Judge Toto.
Yeah, we walked into Toto's office, and then he was unable to really do much because he was in the process of seating a jury.
So you ended up with Judge Rhea.
Yeah, we were able to get a brief hearing with Judge Rhea, who agreed to take on the case and obviously wasn't prepared to rule in any kind of way since he was assigned the case that day, and we agreed to proceed with him. And I got to hand it to Alex. He really, with the power of the ACLU behind him, stood up for me and fought for us to get some more movement before we left the building that day. But yeah, the reason we fought so hard is because we knew that Daniel's Law is going to mean criminal or civil consequences for at least some regular people who can't enlist the ACLU or fund their own defense like major newspapers can. So we were really only able to do this because of the ACLU, and so we're very grateful for that.
So after Judge Rhea finally heard the case, let's hear what Alex had to say about Judge Rhea's ruling.
The case was reassigned to Judge Ray. We had another delay in front of Judge Ray and eventually argued the case on its merits before Judge Ray. He ruled against us. So first of all, he found that the information was true. He found that you had lawfully obtained it. He found that the general issue was one of public concern, but as I said, slicing the salami very thin, found that the particular issue was not an issue of public concern. So he came up with what he thought was a common sense solution, which would be that you would simply write that he lived in Cape May. For obvious reasons, we did not think so. We did not think it was a common sense solution, and we did not think it was what the law required or even permitted.
If I were to write the story, basically the lower courts have said, you can write it, but you can't include the address. And what you're saying is it's not for them to decide what facts get to be in the story. They're not the editor of the story. If it's a public issue, a relevant, if it's a significant public issue,
that it's up to the publication to decide how to write the story, what facts to include, how much specificity to give. And you're saying that these cases are all aligned on that.
That's exactly right. And there's good reason why judges shouldn't be in the business of playing editor and editors shouldn't be in the business of playing judges, right? I mean, those are distinct judges, and that's pretty core First Amendment values that we want to let editors make editorial decisions on, and there are limitations on that. They can't make whatever editorial decisions they want if it's not an issue of public concern, and they can't do so if it's not true. Right? But in this case, and if it was not lawfully obtained, but in this case, it was lawfully obtained, it was true, and it's an issue of public concern.
So after Judge Rhea ruled against you in the lower court, the city wasted no time in declaring victory.
Yes, they went ahead and celebrated the victory over me. Their statement still available on their website says, "Judge upholds Daniels Law in case filed by New Brunswick activist." When the case was all about my rights as a reporter, and the mayor says that my contentions in the lawsuit could not be further from the truth, and we ultimately ended up using some of this against them in the Supreme Court case. He's spending most of his time in Cape May, but if I'm not allowed to talk about how he's spending his time in Cape May, the government can use its power to make me look like I'm not telling the truth. So that was one argument we made ultimately at the Supreme Court.
And then after the city put out their victory statement, they actually made a surprise announcement about Director Caputo himself.
Yes, the city put out an announcement saying that he was going to be stepping down. His reign was coming to an end at the end of the year, just a couple months after that first decision in the case at the Middlesex County Trial Court level. He also ended up leaving his role as a parking authority commissioner. That was because he could no longer hold that position as a non-resident, non-full-time employee. And I gotta think that it would not have happened that quickly if he had not been put in the limelight in the way that he was. You know, if you don't want somebody to know something, you shouldn't make a big deal about it. But when he sent me that letter trying to police my speech, it blew up. People said, wow, I can't believe the New Brunswick police director is abusing his power to try to keep us from knowing that he has moved to Cape May. And so before you know it, there's all sorts of articles out there saying how he lives in Cape May. So the fact that he didn't want people to know actually became known much more widely than I could have ever promoted it myself because of this case. And ultimately, the good outcome here is that he left New Brunswick. But don't worry, he got himself a full-time six-figure job working for Cape May County. They hired him to run their senior transportation program.
Has had experience assisting seniors.
It's true. So yeah, he's making $110,000 to run that senior bus program. So
do you think they're making him show up every day?
I have no idea. I really would be curious to see what kind of a program that is and what the responsibilities are of the director.
So after you received that ruling from Judge Rhea, Alex took the case to the appellate division.
We filed an emergency motion before the appellate division asking them to hear the case right away. And we got a summary rejection where Judge Bishop Thompson indicated that she did not think that we had made a showing of a risk of irreparable harm. There is, and we cited to case law that says that a First Amendment deprivation, even for a minute, is irreparable harm. You had been enjoined at that point for more than a month. So we think that was wrong. We appealed that on an emergent basis to the Supreme Court. They did not take the case, but asked the appellate division to hear the case on an expedited basis. They did. We briefed it before the appellate division. We argued it before the appellate division. I think the argument went quite well. I thought we had made our points. This is one of those instances where I didn't read the tea leaves correctly. The appellate division ruled against us in an unpublished opinion, which is a very surprising approach in a case that deals with an issue of first impression on a law that had gotten a ton of attention. Be that as it may, we filed a petition for certification with the New Jersey Supreme Court asking them to review the case, and they did. They agreed to do so. They granted the petition, and argument is coming up on March 3rd.
What was your reaction when you got that sort of unpublished decision that we lost the case? And it was almost like they were saying,
that the case wasn't ready to go yet because I haven't been prosecuted, right? They basically said, you've got to publish the address first and then get in trouble and then challenge it, as opposed to what we were trying to do, which was get the courts to weigh in before I'm facing consequences.
Yeah, I thought it was a decision that was pretty light on analysis, to be totally candid. I didn't think it had a lot of legal analysis, but you're right. There's something pretty curious about that, which is one way to handle this is for you to publish it and then fight the civil sanction or criminal penalty that might come your way. We didn't. We went to court and said, we want to give you a chance, judiciary, to sign off on this, to figure out how to handle these. You'd think that would be a better process, not just that the judiciary would like it more, but that the police unions and everyone, you'd think this would be exactly what they want. If you're saying, as they have, that most of the time people shouldn't be allowed to publish covered addresses, then when someone says, I'll concede that, but right now I think I have a case where there's a particularly good reason for me to do it because it relates to a matter of public significance, you'd think they'd want you to go to court to sign off on that. And ultimately, that's what happened. They just did the analysis incorrectly.
Right. Pretty much every police union in New Jersey also got involved in the case. Have you ever seen that before with such unanimity on one side in a case like that, with the police all getting together?
Yeah, so unfortunately, I have seen it before. I've been adverse to a whole slew of police unions several times. And so here you had the PBA and the FOP and the State Troopers Fraternal Association and the County Prosecutors Association and the Association of Chiefs of Police all lined up on the side of the city. Curiously, who didn't line up on the side of the city was the Attorney General, who sat out of the case at the trial stage and at the appellate stage. They're now in the case, but they had sat out of it for the beginning parts of it. Their arguments, by and large, were similar to the city's, but there was an interesting point of disagreement between the unions and the city and amongst the unions about what you could permissibly write about and what you couldn't. There's a real problem. When laws are vague, it's hard to know how to follow them. And here you had some unions saying you could say only that he lived 2 hours away. Others saying you could say that he lived in South Jersey. Others saying you could say Cape May County. And still others doing what the courts ultimately did, which is said you could say the municipality of Cape May. But the lack of unanimity amongst them as to that is really illustrative of the way in which the law is vague. The unions also opposed our motion for certification. They sought the ability to argue before the New Jersey Supreme Court now, but were told that they could not. So they have filed briefs, but they were not given the opportunity to argue.
In this case, I was able to obtain the address from Cape May Board of Elections because, knowing that someone owns property somewhere doesn't prove that they're living there or that they consider that their home. But the way I was able to prove that that was his residence was I was able to obtain his voter profile through a Open Public Records Act request to the Cape May County Board of Elections. And talk a little bit about that. They almost made it seem like I had tricked them into giving it up.
So two things to say. The first is, it's not even clear that Cape May got it wrong because it's not, the record does not yet establish when Director Caputo became a covered person under Daniel's law.
Right, you have to apply to get that protection.
You have to opt in, exactly. We know he's eligible for it by virtue of his prior police service, but whether he availed himself of it, the record doesn't reflect. And in fact, because when we showed up in court and argued this,
the director registered for Daniel's law before the County Board of Elections revealed his address.
That I do not know. I know that the director tried to register a number of times with the website, but apparently there was issues with the website initially. He thought that he was registered beforehand, but I don't know what his official date of registration was.
We know that at that time, it was incredibly easy to find his address. If you typed his name and Cape May in, it was the first hit on Google. And because we know that, it's possible that he actually wasn't covered at the time and Cape May didn't air. But even if Cape May did air, you didn't do it.
And Charlie, what were your own thoughts on the appellate court's decision?
It was a really shocking decision that they had said, we can't rule on this because you haven't published the address yet. And they almost dared me to publish the address and say, then we'll decide if you're guilty and you're going to be in trouble. The whole point of us bringing the case was we wanted to get the courts to weigh in before I faced consequences, and we thought we were doing the right thing by doing that, but they said, well, we don't have to decide yet because you haven't published it.
And did they explain why they were taking that view? Because this isn't an unusual thing to do. There are laws that get challenged on a constitutional basis all the time without that person having gone ahead and violated them and going through that process.
Yeah, no, they didn't really give a solid reasoning for why they were ruling the way they did, but we felt confident in challenging it and taking it all the way to the New Jersey Supreme Court. I had figured all along that whoever lost at the appellate level would challenge it and take it to the Supreme Court, but the ruling was so bad that we had to. There was not any way we couldn't challenge that kind of a ruling. Remember, this started as an emergency matter that we were trying to get resolved in July of 2023. We finally got our day in court in September of that year, lost, went to the appellate division in January, got a ruling from them in April of now 2024, and applied for what's called certification to get the Supreme Court to agree to hear it. And the day we finally got there was March 3rd, 2025. So going on 2 years after that fateful city council meeting where I brought all this up.
So when you did your interview with Alex Shalom, it actually took place just a couple days before you went to the Supreme Court. So let's listen to the legal strategy that Alex had planned going into the New Jersey Supreme Court.
Last but not least, we're going to be in court on Monday. Anything you want to share about what you're going to say or your sort of what your strategy is going into this?
I think when the law is clearly on your side, you argue the law. I think we have both the law and the facts on our side. So I intend to explain first why what you want to report on relates to an issue of public concern, and kind of the law around that, talking about the Florida Star. I'll also talk about why the common sense solution set forth by the appellate division and the trial court really isn't commonsensical at all. And what it does is it makes you have this fight with the city about residency with one hand tied behind your back. They're allowed to put anything out they want, and you're kind of limited in what you can do. I'll also talk about the other elements of the Daily Mail test, so that it was truthful and lawfully obtained, though, as I said, I don't think those are much in dispute. And then I'll apply the Daily Mail test. I'll talk about why Daniel's Law in New Jersey, in your case, is not narrowly tailored to achieve the legitimate government interest, the need of the highest order. But there are various alternatives that they could have done, like not distributing the information in the first place, that they failed to do. And I'm going to ask the court to reverse and reinstate your complaint. And what we'd be asking for is a declaration that under the facts of this case, you can publish the home address.
So what happened when you finally got to the New Jersey Supreme Court on March 3rd?
It was my first time in the New Jersey Supreme Court. We had pretty good indication that the Chief Justice was going to recuse himself because he had advocated for Daniel's Law back before it was signed into law. So he rightly said, I can't handle this case. But as it turns out, there were actually 3 of the 7 justices that decided they needed to recuse themselves and not be involved in the case. So one of them I know pretty well. John Hoffman was the New Jersey Attorney General under Chris Christie. I have known him and his father, who's a fairly prominent attorney, and in fact with The elder John Hoffman, I even filed an ethics complaint against him for his conduct as the attorney for the New Brunswick's Housing Authority. So I wasn't sure if the son was going to actually hear the case or recuse himself. So he ended up recusing, and another justice, Douglas Faciel, also did not sit for the case. So that meant there would have only been 4 justices. And so in that situation, what they do is they actually call up appellate division judge to sit on the Supreme Court just for that one case. And so they had 5 members instead of the usual 7. So Alex got to go first. He did a stellar job, and then we got to hear from the other side. And Susan O'Connor was handling the case for the city and for Caputo. You got 5 justices up there, and they're all sort of able to interrupt you and throw tough questions at you. And they tried to throw tough questions at both sides, but there were a couple of moments where I thought Susan O'Connor really didn't make the strongest case for her clients. One of those was when one of the justices asked, well, is there any situation where it would be a matter of public interest to reveal Caputo's address? And
so she was talking specifically about the house number because, right, they had earlier said, oh, maybe you can say he lives in Cape May, but it's not a matter of public interest what the exact number is.
The question was, can we publish his full address? And so this attorney for him was asked, is there any situation? And she kind of responded with some interesting hypotheticals.
What was that?
Well, she said, well, if he was dealing drugs out of the house, that would be okay. She kind of opened the door to all sorts of arguments that some nefarious conduct could mean that the address matters. But to that, I would say, well, what about if he's in a position where there's a residency requirement, or if there's question about something like, can he participate in an election that he otherwise wouldn't be able to if not for having such and such address? But it was just interesting to hear her talk about the hypothetical situation where Police Director Tony Caputo might be dealing drugs out of his Cape May home. And then there was also the moment where she kind of made the case that you need to have 2 different standards. One for these large publications that have a sort of hierarchical editorial structure, basically corporate. The word she uses, conglomerates. So she sort of said, like, well, if it's a conglomerate, they're going to have controls and be able to decide what is and isn't fair to put in the news. But if it's just a small-time media outlet, they shouldn't have the same editorial privilege that's been enshrined in law.
One of the justices jumped right in right there and really kind of schooled her on the law. And let's take a look at that.
So obviously, if you have a conglomerate, you have newspaper reporters and you have levels of supervision with respect to editors. When you're an individual blogger, it is just you.
But in Florida Star, didn't the U.S. Supreme Court discuss precisely the opposite when it comes to narrow tailoring? They said, when a state attempts the extraordinary measure of punishing the truthful publication in the name of privacy, it must demonstrate its commitment to advancing this interest by applying the prohibition even-handedly to the small-time disseminator as well as the media giant. So Florida Star, the statute only prohibited a media giant.
Correct.
And the Supreme Court said it's not narrowly tailored because it needs to prohibit everyone. You now seem to be coming from the opposite perspective and say, you know, the media giant should have editorial control, but an individual blogger should not.
No, what I was trying to explain that there is a difference with respect to the editorial perspective. And I was trying to explain that in response to Judge Sabatino's question, is that courts should be able to make that decision in terms of context, form, and content.
I thought Alex had a really solid response to this when he got his final few minutes to sum up our side of the story. He went straight up against that point that we need to differentiate between big and small outlets.
It's also a funny time to be saying that we can only give rights to giant newspapers, as we know that giant newspapers are no longer exist, right? So Mr. Cradiville's New Brunswick Today has been publishing for 14 years. It does not currently have a print edition, much like the Newark Star Ledger, right? And so that can't be the test. The lower court found that Mr. Cradiville is a journalist. My friends have not contested that. Mr. Cradiville is a journalist. And that gets to my last point, which is
we had this talk about how much can he say and how many facts can he include and what level of detail can he go into to bolster his veracity. And Justice Wayner, after I had written down the two quotes that you read from the press release, that he said this without factual support and what he said could not be further from the truth. We live in dark times where the veracity of the press is questioned by lots of people with lots of power. And the press can no longer just assume that the public trusts them without the inclusion of details in the first instance. And it's those very details that would put Mr. Cradiville in jeopardy here.
Unfortunately, after all this, we lost and got that ruling in June of this year.
What parts of the lower court's rulings did they uphold, and which parts did they overturn for you?
Yeah, so the appellate division had said basically that the address itself was not a matter of public interest, that it more or less didn't matter, that we could do our story without the address and it would be fine. The Supreme Court viewed it differently. They did say that the address is a matter of public interest, and they overturned the appellate division in that regard, but we ultimately lost the case because they don't agree with us that the law was not written in a way that limits the government's intrusion to basically as small as possible, right? We talk about these other cases like the Pentagon Papers and the sort of precedents that only in the most extreme cases can the government issue a prior restraint. In this case, they seem to think that Daniel's law is written in a way that's good enough to restrain people's speech prior to actually making it.
So the ultimate outcome, practically speaking, is that you're still not sure what you can actually publish about Caputo's whereabouts to this day.
Yeah, we're not clear if it's just the exact address or if we could still say the street. Or one thing that we do know for sure is we can say the town. The Supreme Court was clear about that, but the sort of standard they have in there is like basically the address where you would have it to have a letter delivered via U.S. mail. So if somebody were to write a letter to Anthony Caputo and put just the street name and not the house number, would that letter arrive? Maybe. We don't know. So ultimately, that is where the law stands right now.
Any final thoughts on the outcome of this case? And are there any next steps you and Alex are considering on it?
So we didn't win the case, and we're not going to pursue it any further at this time. But what we did do was draw attention to Caputo living in Cape May, and the fact that he finally left his role atop New Brunswick's police department is, to me, very significant. I would say it's a big improvement. And we also shined a light on the potential for Daniel's law to be abused by police officials and others who want to cover up misconduct or silence the truth. Remember, this all started with an investigation for an article, and I'm going to be publishing that article soon. And at New Brunswick Today, we're going to continue to cover the city we love despite all the challenges we've faced over the many years doing this work. And I'm ultimately very hopeful that with Caputo gone from New Brunswick and this case behind us both, that people will continue to wake up to the very real problems of corruption and police misconduct, and that our investigations will continue to serve people here in New Jersey and help bring about some of the big changes that we really need. So, that's how Tony Caputo's second reign as New Brunswick Police Director ended. And since he started double dipping in 2011, he was paid more than $3.8 million in public funds. And that's not counting the public funds that were spent defending him in this lawsuit and many others over the years. So this raises bigger questions like, how does the political machine here keep shielding its top elites year after year, no matter what they get caught doing? In our next episode, we're going to pull back the curtain on the Middlesex County Municipal Joint Insurance Fund. That's the slush fund of taxpayer money that local governments use to protect themselves from legal claims. Leaders here have been using this fund to limit accountability for corruption and sidestep the consequences, while all of us pay the price for those politically connected lawyers and sick settlements. It's been hidden in plain sight this whole time, until years of mismanagement led to a lawsuit for fraud, mandatory state oversight, and the hot mic recording that revealed the ugly truth when they accidentally sent it to yours truly. Stick with us for the story on what led the whole house of cards to collapse. I'm Charlie Cradaville, and this has been The Jersey Machine. Thanks for listening.